Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Welcome, everybody, to our First Friday for October 2024. Thanks so much for being here today. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. And I'd like to welcome you to our firm's live virtual First Friday event for the month of October. I've represented HOAs and condominiums in the state of Arizona for almost 28 years. My anniversary for our firm will be November 1st, and that will be 28 years in business, which I can't believe it. My firm currently represents over 1,000 planned communities and condominium associations in the state of Arizona. And we have been very thankful to work with so many different wonderful boards and communities over the years. I also currently serve on my HOA board, and I have for many years. First Fridays are a great time to get your questions on Arizona HOA and condo law answered at no charge. Here's how First Fridays is going to work today. If you haven't done so already, please submit your First Friday questions in the Q&A box on Zoom or in the comment section on Facebook Live as soon as possible. And then I will answer the questions between now and about 10 a.m. or however long it takes me to get through all the questions. Just a quick friendly reminder, due to the large volume of questions that we receive, this opportunity is limited to one question per association. So if you plan on submitting a question live during this session, please include the name of your HOA or condo and your current role when you submit your question. Okay, first things first, we're going to start up a little bit with some Halloween safety tips, which our firm is providing to you right now on Facebook Live and also on Zoom. These are just some great tips for HOAs to navigate the busy and fun Halloween season. Also, let's talk a little bit about the Corporate Transparency Act. We spent a lot of time over the past month in our free virtual learning opportunities talking about the Corporate Transparency Act and the need for associations, condominiums, and homeowners associations to comply with it by the deadline of December 31st, 2024. For some of you who may not be aware of this, it's a federal law that requires HOAs and condominiums, among other nonprofit corporations, to provide information to the government about the board of directors. And basically, it's an anti-money laundering prevention tactic by the government. There's some lawsuits pending by different organizations trying to get this law deemed unconstitutional for HOAs and condos. But as of right now, we all still need to comply with it. So to help associations that are in need of our services and helping them get the paperwork filed with the government, we are offering Corporate Transparency Act filing services for a fee of $350 per year per entity. And what this will include is we'll help you with the initial filing and get it filed for you by the initial deadline of December 31st, 2024. And then any required updates that you have in 2025, because anytime a board member changes or contact information or the management company changes, we have to file something with the government letting them know about that. So for $350, our firm helps with filing the paperwork that's necessary for the Corporate Transparency Act. We also will do any updates for that as included in that amount for 2025. Because we're getting so many requests to do this from our clients and non-clients, we're asking that you please contact us with your board's approval to proceed with our firm helping you with the Corporate Transparency Act filing no later than November 1st. Time is really of the essence now because everything's due by December 31st. If you have any questions or you want to talk about this regarding your association, please reach out to us at our firm at the following email, info@mulcahylawfirm.com, and we'll be happy to answer any questions that you may have. Okay, let's get right into our questions for this month. Looks like we have about 43 questions right now, which is awesome. Okay, so we have about 40 people here today and about 43 questions, so that's great. Okay, must be busy for everybody today. Okay, our first question is, our HOA is self-managed and would like to file our own corporate transparency report rather than paying our management company that we use for accounting. How do we determine if our management company meets the criteria for 4CI and if their CEO needs to be included on our report? They deal with every financial transaction because they handle our accounting. We're really lucky to have her because her name is Emily Bosworth, and she actually used to be an attorney for the IRS. So she's very familiar with federal agencies and has spent a lot of time getting up to speed on this new law. So anyways, pursuant to, our firm's recommendations, the guidance isn't really clear or explicit on whether a management company, CEO, or owner would be included as a beneficial owner of a community association. So we are recommending it out of an abundance of caution because their activities could be deemed as exercising substantial control. So what I would recommend is see if the CEO and owner would be okay with you using them as, the information, on this particular form. If they're not, then reach out to our firm and we can help you with the pivot. It probably is going to be, the president of the association if the CEO of the management company refuses to do it. Next question, number 2. Our HOA is not a corporation, nor are we registered with the Arizona Corporation Commission or the Secretary of State. We do have CC&Rs that are recorded with the Maricopa County Recorder, but to the best of our knowledge, we have not recorded our bylaws with any governmental agency or office. Are we still required to register with the CTA? Okay, a couple of thoughts on this. I'd have to look at everything. I have to look at all your documents, but based upon what you're telling me that you're not registered as a nonprofit corporation in Arizona, you probably would not need to comply with the Corporate Transparency Act. But again, I haven't seen your documents, so to be 100% sure, I'd need to take a look at it. But typically the first kind of standard test that we look at is, are you a nonprofit corporation? And in this case, you're telling me you are not, so likely you do not have to comply with this. Okay, question number 3. A fellow director is laundering money and or fails to register. Is there a personal liability to other members of the group or the HOA? Okay, this obviously is a very concerning question. It came from a board member. A couple of thoughts. Let's just look at it from 2 angles. Okay, number 1, we have a great cheat sheet on how to prevent fraud and embezzlement in your association, and I would recommend that you take a look at that. I believe this is a hypothetical question regarding the CTA. My thoughts are that take a look at our cheat sheet so that everybody knows, that there are things that you can do to prevent theft and fraud of association funds, and you should be keeping an eye on things. But to go to your question more specifically, I think you're saying hypothetically, what if a director refuses to register for the CTA and it's found that they're laundering money, and again, remember the CTA is kind of like a terrorist, it's to prevent terrorism and laundering of money in an effort to harm the national security of the United States, which I think we can all agree that's probably not likely to happen in an association. But let's just say that hypothetically, we've got a director who refuses to register, and now we have, a fellow director who's not registered under the CTA who's stealing money. Is there personal liability to the members of the group or the HOA? Okay, so a couple things to think about. Usually there is not personal liability ever in a corporation, where you're, a corporation in good standing. So there's a corporate shield around the corporation that prohibits any third parties from, personally going after, the other members of the community or the other board members. There's also insurance. So let's say the other board members are sued for breach of fiduciary duty for not overseeing this other director properly, and therefore he was able to, steal all this money. You have probably insurance coverage for that. There's also a fidelity bond. So do I see personal liability for other board members because a director fails to register under the CTA and then ends up laundering money at the association? It's not a good situation, and I can't say with 100% certainty that there wouldn't be any personal liability because I'd have to look at the facts. Like, did the other board members know about it? I don't quite know yet because the CTA is so new how the federal government is going to handle that. I think there probably would be an analysis as to whether or not the other board members knew about the money laundering. But again, I think this is a hypothetical question, and I really don't see this happening in real life in associations, because there are so many checks and balances with so many different board members who are looking at things. And our experience has been that most board members, like 99.99%, are fully complying with the CTA and are, doing all the paperwork that they need to register. And anybody that may initially not want to register under the CTA as a board member, after we have a phone call with them and just kind of go over the fact that the government already has all this information that's being requested, and it doesn't make sense to not comply with it, I think we've had 100% of the people I've had a phone call with agree that they were going to file it. So, okay, today's a big CTA day. Next question is also on the CTA from a board member. Is completion of the forms all that is necessary to comply with the CTA? Okay, so yes, our firm, can help you with the forms and the paperwork that is needed to accompany the forms, like the information verifying, the board members' information. But yes, generally speaking, yes, it is all you need to comply with the CTA. We have a great frequently asked questions handout that I hope our firm can share with the group right now that I think would be helpful as all of you are navigating this new law. Next question from a board. How does the Corporate Transparency Act relate to board members who are not U.S. citizens? We are not being paid to work in the U.S. and are volunteers, but now that we are registering with the U.S. government as part of the Corporate Transparency Act, is this going to have tax ramifications going forward and put us under scrutiny by the U.S. Tax Office because we are registered as being part of a corporation? So short answer would be no, I don't believe that there is going to be any tax ramifications personally for you or put you under any additional scrutiny by the U.S. Tax Office because you are a director of a nonprofit corporation that's, required to file this paperwork under the Corporate Transparency Act. Okay, question number 6. And honestly, it's really no different than like having a driver's license in the U.S. Basically, it's a box checker to get government information about the corporation. Okay, question number 6. A request to review and audit a vote that took place 7 months ago in regard to borrowing money was reviewed by the board from an owner. Was received by the board from an owner. So what do you think the board must legally allow the owner to view? Ballot and envelopes. A few owners report they received 2 ballots. Okay, so it sounds like you're a prospective board member and somebody made a request, a homeowner association made a request to view an audit vote that took place 7 months ago in regard to borrowing money. And so, basically the owner can see anything that's been kept with the association's books and records on us. So the ballot, the sign-in sheet, the envelopes, if they were kept, trying to think of anything else, the notice of the meeting, the minutes of the meeting. So really they're entitled to see everything. Question number 7. The state legislature amended 33-1808 in 2022 to allow HOAs to regulate profanity and discriminatory text on association-specific political signs. The legislature has not amended the statute to grant this HOAs the same regulatory latitude when it comes to non-association-specific political signs. Are you aware of any reason why the legislature made this distinction? Well, honestly, no. What I can tell you is watching how statutes are made is kind of like watching how I'm from Wisconsin. So I, of course, a lot of beer and sausages in my past. What I can tell you, watching legislation made is kind of like watching a bratwurst or a sausage be made. It's not pretty. When it goes into the casings, it's a mixture of a lot of different things. And that's exactly how I, talk about our legislature. I've been following the legislature since 1996, and I've watched every single legislative year since then. And sometimes there is no rhyme or reason as to why they, change certain things in the law. And, sometimes they change something in the Planned Communities Act, don't change it in the Condominium Act, and they really should have. But on this particular instance, this is obviously a recent change in 2022. I have to think it was specific because, we see a political sign bill, updates on signs and flags and, right to, peacefully meet in an association every particular year over the past 5 years. So I have to think it was intentional that they just made it for association-specific political signs. So like signs regarding our board of directors or signs regarding a removal meeting or signs that might be posted in the community regarding, in opposition of or in favor of a special assessment. So, really good question because there is a good distinction there that needs to be noted. So we're in political science season right now. I think that everybody knows that owners are allowed to have a political sign on their property for local, state, and federal elections. Just as a quick primer, if HOA or condo, owners also want to have something for their specific association issue, whether it's a board election or, some other vote that's facing your association, they're allowed to have a political sign for that on their property. I can't give you a good answer why the legislature, stated that, you can't have profanity and discriminatory text on association-specific political signs, but not on, local, federal, state political signs. I can't give you an answer on that. Maybe they thought it was going to be too hard to control, but they didn't do it is the bottom line. So good distinction. Okay, question number 8. Board members continue to remove a sign posted regarding an upcoming assembly of owners on the community bulletin board. I know ARS allows for posting notice of assembly of owners. Is there any penalty for board members taking down notices for assembly of owners? Well, I guess today is such an interesting day. Sometimes we have questions that are like all over the place, but today it seems like we're seeing a lot of questions on the CTA and political signs and peaceful assembly of owners. So, the bottom line here is that the board should not be taking down any notices for assembly of owners because they have a responsibility under the law to allow those. The legislature amended that section several years ago and says that associations cannot prohibit the peaceful assembly of owners, and that if they ask to have the notices to be placed on a bulletin board or any other means on the association's website, for example, the board has to do it. So I guess the questions that I would have is, do we have proof that the board members were taking down the notices? I would want to know that you actually have proof that they ripped them down, or did they admittedly take them down? They shouldn't be if they did do that. On a different note, I would say that, if they did do it, is there a penalty? There is not a penalty under the law, other than the fact that they could be sued if there was adequate proof for doing it. So I would just say at this point, have the board listen to this conversation about this and remind them of their responsibilities to comply with the Arizona law on this. And if they don't comply, the penalty really would be that there could be a potential lawsuit over it. Although this is such a small issue, I would be surprised if this actually turned into a lawsuit. But sometimes it's a kitchen sink thing where they just throw it in if there's a bunch of other things that they're being sued for. Okay, next question from a board member. In your recent discussion regarding collection of assessments and late fees, that we would need to go to court and secure a judgment to place a lien for these amounts. Can the same judgment be obtained in a small claims court? I would expect this to be less costly. So I think that you're talking a little bit about the new legislation that just went into effect a couple of weeks ago regarding some changes that they had on our ability to lien and, how different charges that are charged to owners are handled. So when we're talking about assessments and late fees that are authorized by the associations, you can still go to justice court to get a judgment against them. You can still go to Superior Court and foreclose the assessment lien for those amounts. Your question is, can a judgment be obtained in small claims court for unpaid assessments and late fees that are authorized by the association's documents? So short answer would be no, because there is case law in Arizona that says that corporations need to be represented by legal counsel in any legal proceeding, and lawyers cannot practice in small claims court, so you wouldn't be able to go to small claims court without a lawyer. So short answer would be, can we get a judgment in small claims court as an association? Short answer would be no, even though that could be less costly. Question 10, occasionally residents request their late fees be waived. Is there any ARS that states how we are to implement this? Can we vary if we waive them and the waiver amount? So great question. So I guess the issue that comes up here is, okay, we have an owner who's delinquent. We've been charging them late fees and we're trying to get them to pay their full debt, right? At first glance, I would say try to get them to pay everything, which would be, any of the fees that are on their ledger. If it becomes a negotiating point where, maybe they're struggling and they, don't have enough money, or they are making good faith efforts to pay back a lot of debt and the late fees, have added up, and it would really help the situation to waive the late fees, I'm fine with board waiving them. Late fees are found money. I mean, obviously, they should be used as a penalty so that people pay their assessment on time. So, I would make every effort to get them to pay it. But if it's a deal breaker that we can't get this matter settled without waiving the late fees, you certainly have the right as a board to waive them, and it doesn't conflict with any laws or your fiduciary responsibilities to the corporation. That being said, remember, if you waive the late fees, sometimes people then they just think, oh, well, I can just pay late every time, and they're going to waive the late fees. So you might just want to waive a portion of them. If they're what I would call a repeat offender, I would definitely not waive the late fees. And I don't think I think you look at each situation with each resident who's delinquent as a separate matter. And just because you waive late fees on one doesn't mean that you have to waive late fees on all. We look at things on a case-by-case basis and just try to negotiate the best deal. I don't think it's selective enforcement because, most of the time we're waiving it like in a situation where either the person, I don't think it's selective enforcement because we're looking at each situation on a fact basis. Like, what are the facts for this particular case? And it's confidential. Typically, when we waive these, it's done in executive session, so the homeowners wouldn't even know about it. Okay, next question, number 11. Our association has 2 buildings. A single owner has purchased 2 condos, 1 condo in each of our 2 buildings. One condo is deeded under his revocable trust, and the other is deeded under his name. They owe 6 months due in one condo and 3 months in the other. May we combine the receivables to eliminate separate collection actions? So I know your association just because I recognize the name. It looks like it's 2 separate entities out there because I think I know that you have it's a condo, and I know that you have a number of different buildings, but each building has its own HOA or whatever condo. So since it's separate legal entities, it's my opinion that you cannot combine them. The other reason is they're titled separately. One's a trust and the other one is the individual's personal name on there. So I think those really do need to be separate actions. Okay, next question, 12. For the second time, we've recorded a lien against a unit. The first time the mortgage company instituted foreclosure, but someone gave the owner the money and the unit wasn't sold. This time, the board was considering foreclosure, but the mortgage company began foreclosure first with the trustee sale scheduled for November. The mortgage company is aware of our lien and other amounts due to us. Might the board recoup amounts owed to it? If the owner is bailed out again but continues non-payment, we will place another lien when at least $1,200 in unpaid assessments is reached. What legal expenses should the board be prepared to incur? Okay, this is a really good question. So it sounds like you have an owner who, has been behind before, and maybe somebody bailed them out when when the mortgage company instituted foreclosure previously. I don't know if somebody's going to bail them out again or not. Here's what I would do. Here's my best recommendation to you. I would look to see, does this owner have equity in their property? And by equity, I mean, let's look at what the property's worth, and then let's look at what the mortgage is. And the best way to find out what's currently owed on the mortgage is look at the trustee sale notice, because they'll give us, how much is in arrears on the mortgage, and we'll tell us the original mortgage amount. If there's equity in the property, it's very likely that this owner is going to either get somebody to bail them out or maybe refinance, or when the property sells at the trustee sale and a third party buys it, because there is equity, we'll be able to make a claim for excess proceeds, and any money that's paid over what's owed on the mortgage or deed of trust, the association will be first in line to collect that money. So I really think this is one that I would recommend that you reach out to a firm to give you a little advice on, because you don't want to lose the opportunity to get money on this. So I guess at first glance, I would say you should record a lien on the property just to protect your interests before that November trustee sale. Secondly, I would say that my recommendation would be to see if the property has any equity in it. We can help you with that. We look up the property value and then we compare it to the deed of trust amount on it. And thirdly, I would suggest that we really keep an eye on that trustee sale in November. And because either the owner is going to pay up and then the trustee sale is canceled, that if that happens, then we need to get aggressive as an association to get the owner to pay. what they owe and let them know we'll foreclose as soon as we're able to under the law, as soon as they reach the threshold of $1,200 in assessments that are unpaid or 1 year delinquent in assessments unpaid. So you have a lot of options on this one, but we need more information to help you. Okay, question 13. Our bylaws state that delinquent owners are not allowed to use community amenities, and pool keys must be returned by those not in compliance. We want to know if we can charge a fee for unreturned keys, and if so, what is the legal limit for such fees? Additionally, are there any specific legislative laws that address this situation? So unless you give you the right to, charge a fee for not returning a key to the pool for being delinquent, you don't have the legal right to do that. What you could do if you want to keep them out of the pool is rekey the pool and just not give them a key. But there's a cost, obviously, to rekey the pool. And there are no specific legislative laws that address this particular situation. Okay, question number 14. An owner received a violation notice for parking a commercial vehicle on HOA property, which violates the CC&Rs. The owner argues the truck is for personal use and questions why it's classified as a commercial vehicle, despite having a company graphics, a phone number, and a registered contractor's number displayed. The board issued a second notice, delayed, and waived the violation fee, but instructed the owner to stop parking the truck on the property. The owner has contacted the Arizona Real Estate Department for review and requests a pause on further violations while awaiting their decision. Should the board suspend further violation actions during this review process? So honestly, here's what I would say. I think a lot of this can be resolved with just good communication. So the first question that comes to mind for me is this an emergency vehicle, which is classified by the state of Arizona for the owner to have it at their property? If it is, you may not have any rights here, and we may have to allow the owner to stop, to park the truck on the property. I guess first things first would be talk to the owner and find out more about, what the classification of this vehicle. Are they really an emergency vehicle as defined by the law, and they have to have their car here at all times on their property? I don't know. I'm kind of doubting it because I'm seeing that it has like a register of contractors and individual companies' graphics, phone, et cetera, on there, which is not typically what we see on an emergency vehicle. If that's the case, when you talk with them, then the next thing I would do is look at do the documents prohibit this person from doing what they're doing, and they're not an emergency vehicle. If that's the case, then, you probably want to point that out to them. And, it sounds like they're not buying it. So then maybe you do have to have a hearing with the Arizona Department of Real Estate to resolve this issue with the owner. It sounds like the owner has already, filed paperwork for, a complaint on this. And, you'll likely have to file a response to that. If you'd like our help with that, just let us know. We've done many of those with the Arizona Department of Real Estate. We've been very successful in handling them. I almost feel like this is one that doesn't need to go that far. Like, I think a couple of good phone calls between our firm and the owner hopefully would be able to resolve this. But reach out to us to see if you might want us to help you with it, because I think this is turning into a big thing and it doesn't need to be. Question 15 from a former board member regarding the dispute process with ADRE for violations. What should the board and individual homeowners know about this process and when to pursue it? So we have a great cheat sheet on enforcement of governing, which kind of outlines that process that's used for the ADRE. I also really highly recommend that you go to the ADRE website. You can find it by just Googling ADRE, which stands for Arizona Department of Real Estate, and HOAs, and it'll pop right up. And it has a full summary of what the Department of Real Estate can do to help associations and owners who are having a dispute with each other regarding the association's or state law. So best way to find out information on that process, go to that website. When to pursue it? Typically, it's owner-driven. Most owners are pursuing these complaints with the ADRE because it's inexpensive. It's only a $500 filing fee per issue, and you don't have to have an attorney. In fact, attorney's fees aren't granted if you go through this process. And it's really just for, typically we see owners using it as a way to get compliance or get boards to comply if they're not following the law. Okay, next question, 16. Assume an HOA managed by its volunteer board of directors. To what extent, if any, can non-attorney board members or officers represent their association in legal matters, such as drafting, reviewing simple vendor contracts, or representing their association in small ADRE proceedings? This is a really good question because we kind of talked a little bit about that all corporations need to have legal counsel when they're involved in a legal proceeding. And so maybe I need to kind of retract about what I said here on the ADRE. I'm not sure how that would be handled if in fact the case that says that nonprofit corporations or any corporation needs to have legal counsel in any sort of a legal proceeding. Now, whether or not the hearing in front of the ADRE is considered a full-blown a legal proceeding, it may or may not. I'm probably kind of leaning towards may. I've never seen anyone challenge it, and I have seen boards represent themselves where it hasn't come up. I suppose if you are defending an ADRE complaint or if you are pursuing one, if the issue is raised, you may have to get an attorney. But in my experience, that issue has not been raised in ADRE hearings. So I guess the gist of the question is, can non-attorney board members or officers represent the association in legal matters? So in a superior court case or in a justice court case, I feel that the judge is going to require them to have an attorney. That's my experience in 28 years. Usually associations are not allowed to go to justice court without having an attorney or superior court without having an attorney, and they can't use small claims as a method to file complaints unless maybe they're using like a certified legal document preparer or something like that. But a non-attorney board member would be able to do that. What about reviewing simple vendor contracts? I mean, I'd be careful on that. I mean, if it's really simple, like it's, a couple $100, I don't think that's a big deal. But if you're getting into vendor contracts, like with your management company, your landscaping company, large capital improvement projects, really like anything that you're spending more than $5,000 on, I do think that you should be having legal counsel review those particular contracts, or any contract that's like an automatic renewal, like a trash contract, Cox Communications contract, internet contracts. Those are all really serious that you do need to have legal counsel help you. Okay, next question, number 17. How can we remove a member from the board of directors who is currently serving without proper authorization or election? The CC&R specified that an appointed officer is supposed to serve only until the next election, and this individual has extended their term beyond what is allowed by the governing documents. Well, and this is from an owner, I'd like to hear more from the board about what's going on here. Like if they aren't able to elect a new director to fill the vacancy, typically that board does stay on. So it's hard for me to answer this question without more information. If as an owner, you really do feel that, this person is improperly serving, you should send a letter to the board or the board's legal counsel and ask them to look into it. Another option that you have is to hire an attorney to help you look into this. Go to the ADRE, file a lawsuit, do a removal petition to remove that board member from office. But I would first start with finding out more information about why the owner director is still operating as a board member after, their term was up. And we also have a great cheat sheet that addresses removal that my office has or will be sharing with you shortly. Okay, question number 18. What recourse does a resident-controlled board have if the declarant does not honor the bylaws and honor his appointed board to serve terms in excess of the bylaws? Okay, so this is from a board member. So we've got a resident-controlled board now. So I'm assuming what you mean by that is it's post-developer controlled. And the declarant doesn't honor the bylaws, allows his appointed board to serve terms in excess of the bylaws. Oh, okay, so I see what's happening here. You've got a mixed board. Declarant board members, and you have resident board members. And you're saying that the declarant maybe is in control of the board and they're not honoring the bylaws and is allowing the appointed directors to serve in excess of the terms that they're allowed to in the bylaws. Well, a couple of things that I would do. I would talk about it as a board, and, because sometimes the declarant does have the right to appoint directors to the board while they're still in control of the board. So they may be very well within their rights as a board. I don't know. I'd have to see the situation and understand the facts and look at the documents. But I would say, look into that, talk to them about it, raise your objections, see what their response is. If you feel that they're still not honoring the bylaws, you may want to get an attorney yourself to look at this. I have the names of attorneys that help owners with issues with associations that I'm happy to refer you to. But without more facts on this, it's hard for me to really talk about it. But you do have recourses. I mean, you can hire an attorney, you can send a letter to the board, go to the ADRE, you can file your own lawsuit. These are all different things that you can do. Remove the directors, but typically the declarant directors can't be removed from office. So, would have to look at this looking at the totality of all the facts. Okay, question 19. If one person board member resigned and 5 others were elected to fill this vacancy in June of 2024, can the board not hold elections until December 2025? Our governing state elections must be held annually, which is typically in December of every year. So in this case, December of 2024. So this question is from an owner. So we have, if a one-person board member resigned. So that means, I see what you're saying. So maybe you had nobody on your board. There was one person on your board and then that person resigned. And then we had 5 people elected to fill the vacancies in June of 2024. Do we still have to hold our annual elections in December of 2025? Honestly, it's really going to depend on what your CC&Rs say. If the 5 were elected to fill the terms of those who, there were vacancies on your board, we really need to look at what the terms are that they filled. Sometimes the bylaws say that whoever fills the vacancy only serves until the next annual meeting. And if that's the case, you probably do need to have your annual meeting in December of 2024. Most of the time it says that they fill the vacancy, the term, they fill the term of the person, whose vacancy was, created. If that's the case, we're going to have to go back and look at, okay, there's a 5-person board, 5 people were elected. Whoever had the highest votes in June 2024 is going to get the longer terms, and whoever got the lower amount of the votes is going to get the shorter terms. If it's everybody got the same amount of votes, then you're going to have to decide among yourselves, but you definitely need legal counsel to help you on this particular issue. Your association should be talking about this, and your minutes from that meeting where they were all elected should have laid this out very clearly so there would be no confusion. Question 20 from an owner. Our HOA wants to host a party with beer and wine. We were denied an event liquor license because we are not a true nonprofit, because we are fully gated and we don't serve the public. Our HOAs that aren't gated, other HOAs that aren't gated can get one. We really don't want to have a bring your own booze event and want to legally obtain a license. Do you have any suggestions? So my suggestion would be I would find an attorney that does liquor law. It's liquor laws, it's state-by-state laws. It's state-by-state law driven. And so find an Arizona attorney that specializes in this and get their advice on liquor laws and whether or not you can reapply for the license. I have some knowledge of liquor law because when I was in law school, I worked for Miller Brewing Company in their legal department. So I know enough to be a little bit dangerous. I know that it's state by state. I do know that there are some firms in Arizona that do a great job on this. And if you want to, you can reach out to me and I'd be happy to give you a referral. Okay, next question. Let's see here is from question number 21. Our HOA has a pool company come on Tuesdays and Fridays every week. The rest of the week, we have volunteers that take care of the pool, cleaning and testing. Is it okay to have volunteers to do this to help us save money on the pool, or is this a legal issue? We have a great blog that we've written on this on volunteers, and it's called Be Wise when it comes to volunteers that we're sharing with you right now. I mean, generally speaking, we need to run this like a business. All associations are a business. We need to run it like a business. I'm a little bit worried about board members or volunteers cleaning the pool because, it is something that, what if they fall and slip and fall? We may have a legal issue there. Also, the testing, if you aren't doing it properly, it could be a bad situation for your association. The county could shut down the pools. So generally speaking, I would not be in favor of having volunteers taking care of the pool in this manner. Okay, question number 22. Our management company contract includes an annual 4% increase in their services. This year, they increased the fee to 32%. We protested, and the company agreed to reduce the fee to the 4% in the contract. However, they have continued to take out a fee equal to 32%. We keep asking the community manager to fix this, and we've been through 2 community managers this year, but it has not been adjusted. What can we do besides obviously finding a new company or hiring an attorney? Is there a state organization we can file a complaint with? So no, there is no regulatory agency by the state for management companies. I think the best thing to do would be to hire an attorney to resolve this. Make sure that you're hiring an attorney that is separate from the management company. Our firm, we never associate with the management company. We are separate. We work with all the management companies, but we never represent the management companies. We only represent associations. So what I don't want to happen is for you to go to the management company's preferred attorney and then they start giving you advice that's maybe not in your best interest. So I agree. You probably need to start thinking about finding a new management company. We have a great cheat sheet on this topic, which you can find on our website at mulcahylawfirm.com, called, finding and selecting a management company. But more importantly, I think that start with the attorney, because we need to, get the management company to stop charging, way over what they're supposed to be charging, number one. And number two, we can help you with the process of finding a new management company. Okay, question number 23. We are a 55 plus planned community. Unless the board provides an exception, no residence can be occupied unless one person is age 55 or older occupying the residence. Since 80% of our occupied residences are occupied by a resident 55 years of age or older, as required by the Fair Housing Act, can our documents legally enforce our occupancy restriction? So it sounds like you're doing everything correct. You're a 55 plus community. Your CC&Rs say that the residence has to be occupied by one person age 55 or older. 80% of your occupied residences are occupied by a resident 55 years of age or older. So it sounds like you're doing everything right. I encourage you to take a look at our cheat sheet on federal laws for community associations, where we talk about the Fair Housing Act. And my opinion, based upon what you've told me, is that you can legally enforce your documents on your occupancy restrictions. Okay, question 24. Are you required to have a homeowner open forum at a board meeting? So short answer would be no. We have a great cheat sheet on this on Arizona's open meeting law, which I would encourage you to look at. We also have another great cheat sheet called board meetings. You are not required to have a homeowner forum at the beginning of the meeting or at the end of the meeting. The only thing but it's a good idea, just so you know, it's a good idea to start the meeting with this so that owners can have an opportunity to talk to the board and have good communication with the board if they're upset about something. But you're not required to do it. The only thing that the board is required to do when they have a homeowner who wants to contribute is, prior to the board taking formal action on something under the law in Arizona, the board has to allow an owner to talk if they want to talk. They can put time restrictions on it, but the owner should be allowed to talk. So an example, like let's say you're approving anything at the meeting where there's a board vote. During the discussion period, so typically it's a motion, a second to the motion, and then there's discussion by the board. If an owner wants to contribute during that discussion period, the board has to allow them to do that. Question 25, should architectural approvals be ratified at an open session board meeting? I think best practices would be, it depends on how things are set up. So if you have a separate architectural committee, they should be taking minutes and they should be the ones that are, making the decisions on, architectural plans that are submitted to the association or architectural forms. If the board is acting as your architectural committee, then yes, it should be done during an open board meeting. I hope that answers your question. If you're saying we have an architectural committee, but we want the board to ratify their decision at an open board meeting, they're not required to do that under the law. Okay, question 26. If we have a workshop session, committee meeting, or executive session, are we required to provide residents with 48 hours notice? So let's see, if we have a workshop session, committee meetings, or executive session, are we required to provide residents? Okay, so anytime a quorum of the board is meeting to discuss association business, so whether it's a regular board meeting or a workshop session, quorum of the board discussing association business, it has to be noticed 48 hours in advance. Executive sessions have to be noticed 48 hours in advance. Regularly scheduled committee meetings need to be noticed 48 hours in advance. That's the law in Arizona. Okay, question 27. Our monthly meetings are posted on our website for the year. Our association had their monthly meeting on Monday evening. The notice and agenda were sent to the homeowners 15 minutes before the meeting started. Does this follow the open meeting law? Okay, so it looks like your board may not be fully aware of the new legislation that just went into effect in September. So under the new law in Arizona, anytime there's a board meeting, we have to provide notice of the meeting and the agenda 48 hours in advance of the meeting. So it sounds like maybe they didn't do that with the agenda, but they need to just get in compliance with that going forward. You are welcome to share with them any information that we have on our website on the new legislation or this discussion that we had here today. Okay, question number 28. For regular board meetings, if on a rare occasion a new item pops up after the agenda is published, can it be added by vote for the current session? For example, the pool pump dies the day before the meeting and a bid is made available. Can it be added to open session, or does it require a new notice meeting or waiting for the next scheduled meeting? So I think that this is something that you could do, just add to the agenda. This is obviously an emergency item, and I think there would be an exception for this. I also think that if you have new business and old business on your agendas, which you should, as you're posting these 48 hours in advance, there's a lot of things that can be pushed into that at the meeting if it comes up at the last minute. Question number 29. Can an executive session or a closed session of an HOA board be standalone meeting called by the board to deal with one specific issue of the 5 accepted reasons for a closed session? Or does closed session always have to be part of a regular board meeting? So good question. You can have a standalone closed executive session. Absolutely. You just need to notice it and provide the agenda. It's my understanding your board held some of these executive sessions standalone this summer to deal with a resident appeals of a rules violation. And some residents said that these sessions were illegal because they were not part of a regular board meeting. Well, they were wrong. Okay, question number 30. Looks like how many more questions do we have? I'm just doing a quick little question check. Looks like we are up to 47 questions. Okay, question number 30. House Bill 2141. This bill could have a huge impact on the value of units on the lower level of a 2-story building. Yet it is vague on the measure of success for home improvements. How does an HOA approve an architectural review form that would presumably eliminate or minimize the potential disturbance without rules in place? What are your recommendations to ensure HOA board and homeowner satisfaction? Well, I think you should take a look at, the most typical example that we have is the hardwood floors example, where the owner on the second floor, wants to make a change to, their unit, and they want to put in hardwood floors. And so I think your board should consider adopting some, regulations to be followed for installation of hardwood floors. Our firm has some. If you'd like to, copy them, we give them away at no charge. So give us an email at info@mulcahylawfirm.com. But really, you have to look at it on a case-by-case basis. So what are they trying to put in? If they're trying to put in hardwood floors, I think having the pivot to have the language already as to what they need to do to get approval for the hardwood floors, having that in place, I think would be a good idea. On the other things, you're going to have to just look at it on a case-by-case basis, because who knows what people are going to submit. Does somebody want to submit, like a recording studio with, a lot of noise? What type of, sound measures are we going to have to put in place? You're probably going to need to act quickly on it, get some advice from your legal counsel. So, what are my recommendations? I think the hardwood floors thing is something that your board should have at your disposal, at your fingertips. So reach out to our firm to get that. On other things, when the application comes in, get in touch with your legal counsel right away and talk about what your pivot is and what you can do to mitigate whatever they're putting in. I don't think this is going to be that big of an issue for associations other than the hardwood floors. Okay, question number 31. If we amend the CC&Rs to extend the minimum rental period from 60 days to a longer minimum period of 1 year, is this minimum rental period of 1 year enforceable? Our CC&Rs currently state, no owner of a single-family residence shall rent or lease any portion of his or her residence for a period of less than 60 days. Provided, however, that any owner as of January 4th, 2019 may rent or lease his or her residence for a period of less than 60 days. However, it shall terminate upon the time of transfer. I kind of summarized that at the end. Okay, so, it looks like the way you did the amendment before was that you grandfathered your current owners. And so if you're thinking about doing that again, to change from 60 days to a minimum of a year, I would recommend that you do that too. This is kind of a complicated issue because, we need to look at what your CC&Rs say about amendment. We need to look at whether this is foreseeable and reasonable for your association under the Camelback case. So before you do anything, I really would recommend that you reach out to our firm and we can talk about the pros and cons of this type of an amendment. I think it is possible, but we have to talk about, the risks, liability risks. We pass something like this that an owner will sue us and what the best way to do it would be, which I think, in my experience, it would be grandfathering the current owners and only making that 1 year for the new owners that buy in after the amendment is passed. Okay, next question, number 32. We are a 55 plus community with a horizontal regime. Okay, so you're an older association. I see horizontal regime, I think pre-1986. And legal descriptions as condominiums. We have 327 units, a community building, and a pool, which the HOA takes charge of from the monthly dues paid by the homeowners. The dwellings are one-story duplexes. Each unit has its own electricity, water, sewer connection accounts, and full insurance for the entire unit. Roof replacement is up to the owner for the CC&Rs. Identical duplexes are next to us, and they are not condominiums. They own the land the buildings are on and their backyards. Their legal description is a duplex residential dwelling unit. How can our community change from condominiums to duplex residential dwellings under the same HOA? Well, I'd have to look at your documents to really kind of evaluate this. And I also want to find out more, like, why do you want to do this? So I will say it's not easy to do this because each owner owns a percentage interest in the common areas in a condominium. And in order to change this to make this more of a planned community, like you look like you want to do, we'd have to likely get 100% approval. But let's talk it through. There might be another way to achieve the objective that you want. And so reach out to a firm so we can help you with that. Next question. We have traditionally transferred any surplus funds at the end of the fiscal year to reserve funds, such as painting, major repairs, with a simple board vote. An association member now wants the money returned to the members without a membership vote. Who is correct? I'd have to kind of see typically this is how it's handled, just so you know. It's usually transferred into the reserve account. But I'd want to just know like how much money it is, and I'd want to look at your documents more carefully. But this is traditionally how it is handled in every association. And so probably what I would recommend is that, we send a response letter to the owner with the legal justification for having the funds be transferred to the reserve account at the end of the fiscal year. The only exception I would make on this is if it was like a special assessment and you didn't use all the money, and when you voted on it, it wasn't clear what was going to happen with that money may have to be returned, but I don't think that's the case here. Okay, question 34. My HOA board does not see the importance of fully funding our reserve, which is currently at 60%. When this was brought up at the meeting, the board stated it's not necessary to fully fund because everything does not need to be an upgrade all at once. Is there anything that can be done to assure we fully fund? Our HOA is now 25 years old. The best advice I can give you on this is, and it says that you're a board member, which is great. 60% isn't bad for the funding, right? But you are 25 years old, and I would rather see you in like the 80 to 100% range if possible. So what I would recommend that your board do is maybe have our firm come in and just maybe do a Zoom meeting with you and talk about reserves and the importance of reserves. I also can share with you right now on our firm's website, we have a cheat sheet on reserve studies and reserves that you may want to share with them. The problem is if you don't have the money fully, funded in your reserve, you're probably deferring maintenance on things, and over time that's going to catch up with you. And then it's going to be an emergency, and then you're going to have a bunch of special assessments. which is not good. So I would consider, maybe have our firm come in, do a boot camp, talk about reserves, maybe even if you don't want to spend the money for boot camp, which would be like an hour, 2 hours of my time, just have me pop into by a Zoom to one of your meetings and talk about where you're going with the reserve, why it's important to have it funded higher than 60%, and a plan for the future. Question number 35. Our budget for postage is under $100, yet certified postage is over $1,000. What correspondence to homeowners should go certified and what can be sent regular mail? So the only thing that has to go certified mail is your delinquency notice prior to a file being turned over to the attorney. That's it. Everything else can go regular mail. And we really recommend regular mail for everything other than the one that we're required by law to send by certified mail, which is the letter that you send the owner before you send the owner to the attorney for delinquencies. Okay. And why do we do that? Because owners never pick up the certified mail. So even when you send that letter of certified mail, we also recommend that you send it by regular mail too, so that they actually get it. Because lots of times people don't pick up those certified letters. And then they say, we didn't get the letter. Show us that you sent it to us certified and that we signed for it. And then it becomes a game. So we send everything by regular mail in our office unless we're required to send it by certified mail. Question 36. We are looking for ways to reduce costs as we prepare our 2025 budget. Besides the monthly statement of account notices, are there any other mailings that are legally allowed to be sent electronically? Annual meeting notice, violation notices, year-end budget notices, etc. Are HOAs allowed to charge a fee to homeowners who request paper versus paperless communications? Okay, so you're looking for cost reduction things for your budget for 2025. The other mailings that are legally required to be sent would be, yes, your annual meeting notice. Let's see, are there any other mailings that are legally allowed to be sent electronically? Okay, so I'm not sure I want to answer it that way. So I guess annual meeting notice has to be sent by U.S. mail or hand delivery to the person. Violation notices can go, they should go by mail. If you want to send by, email too, you certainly can. The year-end budget notice, it just depends on what your documents state. That probably could go out electronically, but I'd have to see what your documents specifically state on that. Are there HOAs allowed to charge homeowners who request paper versus paperless communications? No, I don't think that you can pass that through to them. Okay, next question from an owner, 37. A new board member is making threats about suing the old board. Believes that they mishandled HOA funds and that the reserve account is willfully underfunded because of their mismanagement. The former board members are concerned. Can the HOA sue them for the time they were on the board, and how would that work? So this is coming from an owner. Yes, anybody can sue anybody, but is it a good idea to sue the former board? Probably not, because they're just going to be able to tender it to the association's insurance company, and it's like suing ourselves. So basically we're suing the former board members and they're, tendering it to the insurance company. Now we're on opposite sides of our insurance company, which doesn't make sense. So I usually say to new boards, draw a line in the sand, move forward. The only exception to that would be is if there was serious fraud or embezzlement, like over, a large amount of money, like over $100,000, $200,000. So I don't think that the former board members should be too concerned. They are entitled to indemnification. So if it's not covered by the insurance company, which I'm pretty sure it would be, then the board would have to pay their out-of-pocket legal fees to defend themselves, which also doesn't make sense. So I think your board is kind of in need of direction. The new board needs to talk to an attorney that understands these issues to give them good advice. Next question, number 38. Should bylaws, CC&Rs be kept separate? So yes, they should. I don't think you should have the stuff that's in the bylaws, which is how to run the association, commingling with the CC&Rs, which are the property use restrictions and, the obligation to pay assessments and the need to carry insurance, et cetera. Okay, question 39 from a board member. CC&Rs grant an easement authorizing the right to enter a homeowner's property for specific reasons without permission or notification. One homeowner demands permission and joint scheduling for entry. The association is not agreeable, citing the CC&R provisions. The homeowner calls the police to report trespassing. A board member suggested reporting to ADRE, the Arizona Department of Real Estate, but a majority of the board disagreed. Is the ADRE an effective way to resolve this type of dispute? So, no. This type of dispute just needs to be handled with much better communication. The board wants to, enter a property of an owner, right? For whatever reason. I don't really know what the reason is here. I don't know if it was like an emergency or if it's just like, hey, we're going to come in and look at the addition you put on because we think it violates the setback requirements. I don't know. If it's an emergency, it's a little different situation. The setback requirements is not, in my mind, an emergency, but, an unfenced pool, might be an emergency in my mind. If there's access from the common areas to the pool without a fence. I think this is a perfect case of we just need to communicate better. Is the ADRE going to resolve this dispute? Probably not, because, yes, they could hear it, but it seems like a really petty issue, and it doesn't seem like this is something that should go to the ADRE. This seems like this should be resolved with, good communication. Okay, question 40, regarding the law about HOAs and chickens. If our current 1995 CC&Rs do not mention anything about chickens, how are we able to state in our proposed, revised, and not yet voted on CC&Rs that they are not allowed? It is my understanding that HOA CC&Rs have priority over state law regarding this. So the chickens now are covered under the state law umbrella and not covered under municipalities' laws, per se, under the new law that went into effect. So yes, the HOA CC&Rs can be more strict. And if you want to prohibit chickens, you can put that in your CC&Rs and it would be enforceable. Question 41, how should the board handle the situation when the board president goes against a board decision, thus breaking the rules? Well, I think you should talk about it. I think as a board, you should, during an open board meeting, talk about the situation. If you want to do it in an executive session, you probably need to have your attorney there. To make it fall under the advice from attorney category, we could talk about it in executive session. Maybe there were extenuating circumstances. Maybe the board president is on a power trip and doesn't care what the rest of the board thinks. I don't know. But it's probably not a good situation. Some solutions: bring in an attorney to mediate the matter, remove the officer from the position of being the president, and just have them be a director at large and re-elect somebody as the president of your association. The board likely has the right to do that under your bylaws. Question 42, our new treasurer discovered that CDs are in the former treasurer's name. The former treasurer isn't cooperating, providing incorrect information, and refusing to share bank statements. The bank is online only and hasn't responded to inquiries. The new treasurer is hesitant to act without verifying CD ownership. What steps should be taken to resolve this issue, considering the former treasurer's poor health? I'm very worried about this question. So it is concerning me that CD should never, ever have been in the former treasurer's name. It should always have been in the association's name. And the fact that the former treasurer is in poor health, all of this is really worrying me. It's worrying me because it has all the warning signs of fraud and embezzlement. And so I really think you need to get in touch with our firm ASAP to discuss this issue. Okay, question number 43. If an adjoining property has vegetation hanging over the block wall of another homeowner's property, does that homeowner have the right to trim or cut it? So short answer would be yes, right up to the property line. But try to be nice and work it out with the owner first, see if they'll do it themselves. If they won't, then you have the right to trim it right up to the property line. Question 44. I read your transfer fee information, and I think we illegally put a section into our CC&R amendments. It states that we will collect $400 when a home sells, pursuant to ARS 33-1806, to compensate for resale disclosures, lien estoppel, and other services. I think that this is the wrong section for one thing. We have 2 condos that are selling, and I'm wondering if we should make sure they don't pay that. Guess we will need to do another addendum to remove or change it. Okay, so I think maybe there's some confusion. So there's 2 different laws that you need to be aware of, right? There's one that talks about transfer fees or disclosure fees. And then there's one that talks about, there's one that talks about transfer fees or capital contribution fees. And then there's one that talks about disclosure fees. So likely the section you're citing first in the CCNRs here is for planned communities, and it sounds like you are a condo. So you're citing the wrong section, but it basically just says the same thing. So it's not a big deal. But my advice to you is, hey, you just need to pick up the phone and call our firm and show us the paperwork, and we can give you an answer on this pretty quickly. But it doesn't sound like there's anything wrong with it because you can charge the $400 for a disclosure fee to new buyers to disclose information about your association to the buyer. A transfer fee is more complicated. That needs to be in the CCNR. So give us a call. We'll help you on it. Otherwise, check out our disclosures and transfer fee cheat sheet. Hopefully you can reread that and understand that the $400 is for the disclosure fee, and it's under Arizona law. And it sounds to me like you can charge that. Okay, next question, 45. How would an HOA know whether the city of Goodyear has issued a short-term rental license to someone who has a short-term rental within their community? Most cities have the listings online, so you might be able to check that way. A few things that I would do. So number one, I would check with the assessor's office, type in the address of the owner's address that has a short-term rental on the assessor's website. So Google Maricopa County Assessor's Office. When you get to that assessor's office page, click on it and then put in the address of the short-term rental. First, see, is it registered as a rental with the state? If it is, that's the first thing. If it is, great. And we're going to go to the next step. If it's not, you need to contact the assessor's office and let them know that, hey, this is being used as a rental and they're not registered as a rental, and they will investigate it. If it is registered as a rental with the state, meaning the assessor's office, then I would go to the city of Goodyear. I'd call their number and just say, hey, how do I know if someone has a short-term rental license? They may say it's on the website. You might even be able to find it on the website alone yourself, looking online, or they'll tell you how to find out if it is a short-term rental license with the city of Goodyear. So I would recommend check with the assessor's office, then call the city of Goodyear, check out their website. Okay, question 46. With the continuing legislative changes to House Bill 2648, would a material event that comes under House Bill 248's jurisdiction that happened prior to September 14th come under the statute in place when the event happened, or under the version of the statute that became effective September 14th? So really hard for me to answer that question, but let me see what we can do. Okay, so I think what you're asking is, okay, if we handled something before September 14th this way on assessment collections, do we have to go back and undo that? I would say no. I would just say going forward after September 14th, 2024, that any liens that you put on the property comply with what we can lien for. That, any new lawsuits that we file comply with the requirements under, the new statutes. So I wouldn't go backwards. I would only go forwards. I hope that answers your question. You're saying, would a material event that comes under that happened prior to it? So I think that's what you're saying. So anything before September 14th, don't worry about. Going forward, September 14th, comply with the new law. Okay, we have one question from Facebook. Yay, thank you, Facebook viewer. By Arizona law, to be a member of an HOA, do all names have to be recorded on the deed? So short answer on that would be yes. The exceptions to that would be like if it's a trust or maybe like an LLC or a corporation, typically just the corporation's name is listed on the deed. If it's a personal transaction, meaning like I'm transferring it from myself to my husband, his name would have to be on there, obviously, to be a record owner. Okay, so great day today. We had 47 questions and a lot of viewers joined us today. So thank you so much for being here today. Just want to give you a couple quick reminders as we close out today. First, don't forget that we have our October virtual HOA Academy happening on, Tuesday, October 15th at 11 a.m. This will be class 10 of our 2024 virtual HOA Academy. And we're going to be talking about the new legislation that's impacting HOAs. And we're going to discuss federal laws pertaining to community associations, including a deep dive into the Fair Housing Act. And we're also going to be providing tips on preventing crime and limiting liability in HOAs and condos, which came up today in our discussion. So I think that's going to be a really great class for our October class. So please be sure to join us on Tuesday, October 15th, virtually. For our virtual HOA Condo Academy, you can find out information on how to get the Zoom link on our website at mulcahylawfirm.com. We also have an in-person learning opportunity happening Monday, October 7th. We're going to be teaching a class in person for the Scottsdale Neighborhood College from 1 to 3 p.m. You can find out more information on that on our website, mulcahylawfirm.com. But in this session, we're going to be exploring the unique relationship between associations and management companies. And we're going to provide practical tips for how to work together as a team and what to do if things aren't going well, including talking to the management company about problems, firing the management company, and hiring a new management company if necessary. So 2 great free opportunities for learning for HOA board members, owners, and managers this month. So hopefully you can join us for either one of these or both. Again, information on this will be posted. It is posted on our website at mulcahylawfirm.com. I hope everybody has a great rest of the month. I will hopefully see you before Halloween, but happy Halloween if I don't. And thank you so much for caring about your associations and being with us here today. Take care, everybody. Have a great day. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.